Okay, last time we talked about comparative negligence. I just want to add a few remarks. It's important, I think, to keep in mind the four rules. First is the common law rule, in which basically the answer will oftentimes be zero. And so if a person has, a plaintiff has filed a case and it turns out that he has, to any degree, even 1%, been careless for his own safety, been negligent for his own self. That's contributory negligent, and that means he can collect nothing from a plaintiff who is maybe 99% at fault. He can get nothing under the common law rule. How often that actually happened is another question. The juries may have just simply not assigned such a plaintiff any fault at all. If they knew what the law was, they would maybe hesitate to say, oh, he's 1% at fault, knowing that he would get nothing, or 5% at fault, knowing he would get nothing in that case, because his negligence was slight. They might. But on the other hand, as we've seen, sometimes the judge might decide, as a matter of summary judgment, that a plaintiff was contributory negligent, and therefore dismiss the case, denying him any recovery, which was perfectly legal. And actually, and if he didn't do that, there's a good chance if that there was some sort of case where he had actually violated a statute, negligence per se, there's a good chance that there could be an appeal to the Supreme Court, basically, and the Supreme Court would be saying, oh, well, the judge should have issued a summary judgment. So, and we talked a little bit about that. I don't know if I made it clear enough. Anyway, I'm making it clear now. Parker versus Redden is a Supreme Court of Kentucky case, and the facts were rather interesting. Plaintiff stopped to assist a stranded motorist stuck on a narrow mountain roadway. If you've ever been on a mountain roadway like that, it's windy. There are rises, and it rises and falls the road as it goes up and down the mountain, and therefore driving along you're never quite sure what might be around the bend, what might be over the rise. And in this case, the plaintiff stopped his truck down the road, not behind the driver's car. The driver was out of her car trying to change the tire, and he maybe felt sorry for that poor little lady who was trying to change the tire on her car. So he stopped his truck down the road away where it was probably safer to park. Maybe there was a wider stretch of road down there where he could park his car safely, where he wouldn't be worried that it'd be hit. So he then walked up the road, and he set out flares, and he sent the lady up the road with a flashlight to wave off oncoming drivers, to warn them that they ought to be taken care. But some drivers don't take a warning very well. So Speedy was that way. Speedy comes up the mountain, going over the rise and going to be going around the bend, sees the lady with the flashlight, sees the flares, and being an ignorant as he is, a bad driver, ignores her and proceeds on without slowing down at all. So, the speed limit is 35 because, why is it 35, not 55? Well, because it's dangerous to be going that fast on a roadway where you can't see around the bend. So the reason that they oftentimes will lower the speed limit out in the countryside or up on a mountain will be because you can't see what's coming up. And that's the traffic engineers will do that. So that's why when you see a sign that says 35 in the middle of the road where you've been going 55, you should slow down. It probably means that conditions are such that you can't see very far ahead. And there might be something on the other side of that rise that shouldn't be there, but might be there nonetheless. In this case, it might be a stranded motorist like this lady. Anyway, so he was in the back of the car changing the tire when Speedy comes around the bend, and he's in the lane, and Speedy realizes he can't go out to the outside lane to go around Sam, who's the person who is the Good Samaritan who stopped to help out. The Good Samaritan Sam, who stopped to help out, was there changing the tire. Perhaps he sees him and may try to get out of the way, but he's not able to get out of the way. And Speedy doesn't want to go to the outside lane because there's cars coming up. So he really didn't have any way of actually driving safely at that speed he was driving at. So he's going 20 miles over the speed limit. He was clearly negligent. And, you know, the defense that the Speedy had raised by his lawyer was that of assumption of risk. That Sam, the Good Samaritan who stopped to help, was actually assuming a risk. And he was, wasn't he? The only question I have is, was that risk an unreasonable risk, in which case it was actually contributory negligence, or was it a reasonable risk, in which case it's only assumption of risk? But does it matter? Under the common law, either of them, if you had any degree of fault under either of them, you would be completely barred from recovery. And so Sam's lawyer applied for it, and he requested that the judge issue a summary judgment. The judge, being a peckerhead, went ahead and gave him the summary judgment rather than let it go to the jury. If he'd let it go to the jury, I think there's a good chance the jury would not have put any liability, any fault on Sam, because people tend to do that, even though they're instructed by the judge that they should find for assumption of risk. Doesn't matter. The jury can act independently. Doesn't have to follow the judge's instructions. In other words, the juries can defy actually the law. This is an old principle going back to days before the Revolution, in a case involving a journalist who had told the truth about a villainous governor who was a scoundrel and had embezzled money, and he printed it all up in his newspaper, and he was sued for libel. In that case, and under English law, which we were a colony then, the jury refused to find him guilty. That's called jury nullification. They basically nullified the law. And after that, our law has always said that truth is a defense. They found him guilty because they believed his defense, which was that everything he said about the governor was truth. And so we've had that law ever since. And we've also had jury nullifications, probably in many cases. And I think this is one area where we probably had it a lot. Juries would just say, we're not going to find this person to be at fault. But a judge coming from a different sort of people, who was really interested, say, in the railroad not being liable, might actually tend to favor the railroad, even though he maybe shouldn't. And therefore the judges sometimes were maybe a lot different than the jury, which is why plaintiffs generally favored having juries, and defendants in criminal trials generally favor having juries because they tend to be more sympathetic to individuals facing the law. That's an interesting kind of thing. Are we a changed people now? Are we a more harsh people? Are we a people who are very legalistic? Maybe we are. So what are the issues here? Was plaintiff assuming a risk? I think it's safe to say he was assuming a risk. Did he act unreasonably? I think it's correct to say he did not act unreasonably. That what he would do we want to find a person who stops to help somebody out like this? Do we want to find that his behavior is unreasonable behavior? Probably not. We have a choice there to decide whether that's reasonable or not, and we could say, well, we think it's reasonable for him to do this, and under the situation on a narrow road like that, you can't get the car off the road. There isn't enough roadway. There isn't enough of a side to the road. You can't. Oftentimes it's just a very 2 or 3 feet, and that's about all you can get over on that side of that mountain, maybe. And so he couldn't have gotten over more than that. And so he was doing the right thing by putting out flares and having her go up the road with their flashlight. Shows that he knew there was a risk. And he was taking those precautions what a reasonable person would have done. So for that reason, I don't think he was doing it unreasonably. You could argue he's not doing it unreasonably because he took all the precautions under the circumstances. He did something that was very sensible. Anyway, so I would say that he acted reasonably. But nonetheless, assumption of risk in many states like Indiana Ohio, Michigan. Well, no, not Michigan. Michigan follows the same rule as Kentucky. Kentucky changed the rule. Kentucky looked at this case and said, we've never had an assumption of risk case where the risk assumed was a reasonable risk, and therefore we don't feel bound to do it. We know that other states have, we know that England has, but we don't feel bound to do it. We don't feel bound by English precedent that we inherited from the common law. And so they struck out on their own and said, we're not going to recognize assumption of risk where the risk assumed was reasonable. This was in the 70s, I believe, before Kentucky adopted comparative negligence. And they would have been completely banning him from any recovery, therefore. So what the rule is now, it may have changed. The legislature in Kentucky may have changed it, and maybe they put back assumption of risk that's reasonable as a bar to recovery in cases if it's more than 50%. Or maybe they just say it's going to diminish the recovery. Anyway, that's just what they did in Parker versus Redden. In the 70s, Michigan had a similar rule at that time. As a matter of fact, they cited this Michigan rule at that time. Summary judgment is required in this case if you find, I think you could say the case could have been appealed if the judge had not issued the summary judgment. And the Supreme Court could have said then, well, summary judgment is required if he did assume a risk and if it's reasonable. So if the judge made the determination that it was that the risk assumed was a reasonable risk, there clearly was an assumption of risk. He found both of those. He found that there was clear assumption of risk, and he found that it was a reasonable risk. No, I don't think he actually talked about that. I think that was just something that the Supreme Court talked about. Now, if he had talked about it, you know, would that have bound the Supreme Court? I don't think so, because it's a matter of argument. And, you know, so I don't think that, anyway, the Supreme Court in Kentucky wouldn't recognize it as being a reasonable risk to assume, saying that they didn't want to find a good Samaritan like this to have acted unreasonably, especially when he took all those other precautions. Okay, so that's Parker versus Redden. Now we'll go to another case. We're going to be talking now about social host liability statutes. Okay, so we didn't get to that last time. So Indiana, my understanding is that we do have a social host liability, but I don't know that we have a statute. I think it's possible that we're just following the common law. So the common law had a rule. The common law imposed social host liability on adults serving a minor. So if you're an adult and you're serving minors alcohol and they get drunk, and then you let them go out and get into the car and drive and they have an accident, you become responsible for anybody they injure on the road. Are you liable for them themselves? No, not actually under the common law. the individual himself, the minor, under the common law rule, common law rules were oftentimes harsh, he was not covered by that. Okay, even at say 18, he might be thought to be, you know, responsible for himself. Certainly at 17 or 16, he might still be held responsible, you know, because common law was certainly a different era. And so that was the common law. But we do have states that have adopted a statute establishing social host liability, and in some of the cases it actually expands it. In others, it just simply repeats what the common law says in a way. So in Ohio and 18 other states, Ohio being one of the 18, an adult serving anyone of any age, whether a minor or an adult, that adult becomes liable as a social host if he serves an adult who is clearly or obviously or noticeably or can be proven to have been in a state that he should have known that he was intoxicated. If he serves that individual knowing that he's had too much to drink, he can then be held liable. And actually, if he's a caring host, he probably wouldn't allow him to go out and get into a car and drive anyway, drive him home, or make other arrangements. Let him stay the night, let him sleep on the floor, let him sleep it off there, you know. And so 18 states have actually expanded what the common law has had. There are 9 states that have statutes, and this includes Illinois and Michigan, but they simply keep what the common law has, so they didn't expand the social host liability. Although they reported it, I mean the newspapers reported it as if this was some sort of breakthrough. That's because the newspaper reporters oftentimes don't know what the law is unless they ask somebody, and they oftentimes don't do much in the way of investigation because they don't get paid to do investigations, it seems. Our newspapers have deteriorated over the years because newspapers are not paying for a lot of investigation. They just simply take whatever somebody tells them. So if you're a corporation, you just tell them what they want. If you're a government official, you just tell them what they want. That's what they'll publish usually. They won't look at it very deeply. Most they'll do is kind of ask you a question, and if they know anything, they might know enough that there is something else beyond it. But a lot of times they don't necessarily know that because we don't pay journalists very much, do we? Unless, of course, they become famous, you know, and become the anchor of a channel, then maybe. But you get what you pay for. So the news we get, if it's bad, if it's fake news, they're maybe repeating things that they saw on the internet. If they're doing that, we're just paying for what we're getting what we're paying for because we're not paying them that much oftentimes. And you know, anybody can publish things, right, on the internet. And most people are not getting paid to do it. Now they may get ads if they're doing it a lot. And I have watched some of those, and some of those people do a very good job. Others, I'm not so sure they do a very good job. So so what I'm saying is, I think in the early 20th century we had better journalists, but we paid them more. They got paid more, or they took more pride, or whatever it was. Anyway, so that's social host liability and social host liability statutes. Now we're going to talk about joint and several liability. Joint and several liability is very interesting. If one of two or more defendants who are responsible for the injury to plaintiff is unable to pay, the other defendants will be required to pay the unpaid amount. So they'll split it up according to their degree of fault. Now, this is very clear where you have, you know, a pure comparative negligence law. What do you do in terms of where there's been some comparative negligence and there's you know, a 50 or 51% rule? They'll just be dismissed completely. So there will be plaintiffs who, because of our modified comparative negligence, compromised comparative negligence, will be no better off than they would have been had it been at common law. So they could be only 50% responsible for their own injury. In many states they'll be denied recovery. Other states maybe 49%. They'll be able to recover. Okay, if one or two or more, so we covered that last time, and so that's joint and several liability. The defendant who pays, now these defendants who pay more than their degree of fault can try to collect from the non-paying defendant, so he'll remain liable for that, and they can pursue him. Say he wins the lottery, then they see him, hey, he won the lottery. They can sue him, they can collect the money. Or they find out he got a job. He had no job before and he had no money, but now he's got a job, be able to garnish his wages. Or he had a great inheritance. His rich uncle died. They found out about it, so they could pursue him in that. Or they could just make inquiries all the time and try to collect from him. If they, you know, find that he has suddenly become successful, then they may be able to collect. Otherwise, they're just out of luck. They had the bad luck of having committed an accident in conjunction with other people or another person who wasn't really financially responsible or wasn't able to bear the financial responsibility that he ordinarily would have had to pay. And so that's just bad luck in some ways. Is that fair? Well, you have to look at it from all parties' side. And so the rationale of the common law courts who made this rule, and it's one of the better rules I think made by common law, is that it's better that the loss, you know, fall on a responsible defendant than on an innocent victim. So this, I mean, this is where I get back to saying it's, you know, one thing where, you know, you don't have contributory negligence. You don't have any contributory negligence, you don't have any assumption of risk, where you got a plaintiff who is not in any way responsible for his injury. And then you can say, well, he's an innocent person. Why should the loss fall upon him? oh, well, okay, if you buy that, then I guess you might also buy the fact that he should only bear his degree of fault. And so those other people who are at fault may actually pick up to their degree of fault the loss. So he will not be able to get as much as maybe he would have had if all of the defendants had paid, because since he was to some degree at fault himself, he'll bear part of that loss, will not be distributed to the other defendants. And if it is, to whatever degree it is, they can try to collect from the defendant who was financially unable. And they need to make an attempt to collect from it. The plaintiff needs to make an attempt to collect before he can get a judge to order this joint several liability. So, the judge doesn't automatically issue it when the guy doesn't pay. He says, well, have you attempted to collect from him? So, you have to go through trying to collect, maybe trying to trace him, and not being able to collect anything from him after a while, and going into court and say, well, this is all what we did to try to collect from him. We're unable to. Maybe we don't know where he is. He's fled. Or maybe he just doesn't have any money that we can find. And, that's joint and several liability. So joint and several liability is a rule followed in some states in which two or more parent parties can be held independently liable for the full amount of a personal injury. Or, in some cases, there might be more than two. Doesn't matter, two or more. Okay, personal liable for the full amount of a personal injury on plaintiff's damages, regardless of their respective degrees of fault. So one of them, let's say that a party, let's say it's an accounting firm, okay, and the accounting firm has done an audit, but they were negligent in doing the audit. And so there's all these investors who lost millions of dollars. And they're wanting to sue the firm that cooked its books. They want to maybe sue the officers of the firm, but they can't get satisfaction from them. They're not able to collect all the money that they've lost. And so they want to collect under joint and several liability from the accounting firm, which is only 5% responsible for the losses. Under this joint and several liability rule, they can collect from that accounting firm. So accounting firms are really been upset about over the years, and many times have tried to have that law changed in their regard. But this law also applies to you if you happen to be involved in a car accident. The other party is 95% at fault, you're 5% at fault. The defendant is, I'm sorry, the plaintiff is not at all at fault, so there's no contributory negligence, no comparative negligence. And the 95% at fault individual who was drunk and speeding and going over the line, and all you did was, slam into the rear end when after the collision happened. So you did contribute to some damages, and you should have been keeping a safer distance. You should have been following so close. So you were negligent, but the jury decides your negligence compared to the other defendant was minor, and so they say, okay, he's 5% at fault. But he winds up paying maybe the whole 100% if he can. He can file bankruptcy if he can't, because he's not maliciously negligent. He's not subject to punitive damages or anything like that. He's not extremely negligent. He's not grossly negligent, so he can actually file bankruptcy. But he has to pay as much as he can up until the point where he becomes bankrupt. And so it's an awful tragedy for that individual, right? Just because he was following too close. Do you follow too close in your car? I hope not. Very dangerous thing. I know sometimes a driver might be driving slow, he's driving the speed limit, or maybe even under the speed limit. And you're in a hurry to get somewhere, but have respect for other drivers on the road. There's possibly a reason why that fellow is driving slow, and therefore, in some cases, it might be a better reason than you think. So one time I slowed down my car, and a car behind me, which had been following me on my bumper, despite the fact I was usually going like 5 miles over the speed limit, sometimes even more, he would stay on my bumper no matter how fast I go, so I wasn't going to go more than a speed that I thought I could get away with if a policeman was around. So I go 5 miles over the speed limit, and this guy passes me. But he didn't see what I saw. The reason I had slowed down was because there was a deer approaching from the left. He didn't see that, and he slammed into the deer. Well, that's too bad for him. It damaged his car. I know his car was broke down. So, you know, there might be a reason why that guy's going slow. And, you know, you can't necessarily see everything that he can see in front of you. And so don't do it. You know, and also something like this could happen to you too. You could be wind up being wholly liable, even though you might say, well, I wasn't really a whole lot at fault. My negligence wasn't very big. No, it's not gross negligence, but it's very common to do, maybe even, but it's something you shouldn't be doing. Under a joint and several liability, a single tortfeasor can be made to pay for all of the damages. So you might have 5 people who are responsible for the harm, and you might have one person paying for the whole amount if 4 of them happen to be deadbeats. You can't squeeze orange juice out of a lemon, right? You can only get lemon. Okay. Or you can't squeeze blood from a turnip. Anyway, a single tortfeasor can be made to pay for all the damages if he or she is only responsible for the plaintiff's injury to a small degree, for example 1%. If the plaintiff collects from only one jointly and several liability, that defendant can pursue the other responsible parties for a contribution in regard to their respective amounts of fault. And like I said, the plaintiff's claim is reduced by his degree of negligence in any case, regardless of which kind of fault statute you have, what kind of comparative negligence statute or fault statute, or whether you can retain the common law rule. Well, the common law rule, he wouldn't be able to collect for anybody if all of them were contributory negligence. Well, they would all have to pay, right? No, if he was contributory negligent, he couldn't collect from any of them, even if he was only 1% at fault. A harsh rule. If the plaintiff collects from only one jointly and several liability, that defendant can pursue the other responsible parties for contribution. Usually the defendant's liability for damages is reduced to the extent that the plaintiff was negligent. Not all. So the defendant's liability for damages is reduced by the plaintiff's negligence. Not all states follow the rule that of joint and several liability, and many follow a hybrid rule. Some states, such as Alabama and Delaware, do follow a pure rule of joint and several liability. The hybrid rule would be maybe something less than, giving him less than full recovery. So there might be a limit to how much he can collect under joint and several liability. This is called tort reform. And like I said, there are certain groups, like accountants, who actively try to eliminate their being jointly and severally liable. But for the most part, we drivers are jointly and severally liable. If we happen to have the misfortune of being negligent in a case where somebody else was even negligent besides us, and they don't pay, we wind up paying their share. This means that if a plaintiff in a multi-vehicle car accident wins a money judgment of $100,000 against 4 defendants that are jointly and severally liable, each of them is assigned 25% of the $100,000. So they have to pay $25,000, right? And the plaintiff can try to, if one of them doesn't pay, that 25% will be divided up amongst the other 3. So they would each be required to pay a third of that. And the plaintiff can try to collect the full $100,000 from any one of the defendants. Well, this would be in a case where there is no contributory negligence, so we eliminate that. And the mathematics is not difficult, so if I give you this question on an exam, you'll be able to answer it fairly well. Strict liability. Now we come into liability without fault. And there are 3 kinds of things that can make you liable without fault. Ultra-hazardous activities. Are you dealing with hazardous substances that can explode or burst into flames? Chemically toxic substances, radioactive substances. Those kind of substances that are highly volatile and likely to cause injury if they escape, you can become liable for. We'll start off with a case that involves actually flooding, but that's another issue, and so we'll see how that developed. So, animals with known dangerous propensities. You have a dog. If he's not a dog which has aggressive tendencies, doesn't seem to be hostile, you might be safe for quite some time and not ever be liable for him. If he did bite, as long as he just does it one time, or if he does attack somebody, you can claim, well, I didn't know he had these tendencies, you know. But once he's attacked a human being, and I'm not talking about a dog. Now, in Indiana, there are statutes that will make you liable if your dog attacks a dog. But this is by statute, so this was not at common law. And this, so when we talk about strict liability, we start with the common law. And as all these things, we start with the common law. So by statute, you at common law, you were not responsible. You could not claim any liability. You had no claim against another owner who had a dog who attacked your dog. Even though your dog got killed, you had no claim, even though he might have been a very valuable dog. You know, and what would be a valuable dog? A hunting dog could be a very valuable dog. I was told by one fellow that during the 1800s, that bribery in Kentucky legislatures was usually taken by giving people hunting dogs because they were very valuable at that time in Kentucky. So he said, yeah, that's how they would bribe people, give them hunting dogs, you know, good hunting dogs, maybe horses, I don't know. Animals with known dangerous propensities also will make you liable without fault, and we'll talk about these cases. The last thing is products, unreasonably dangerous products. It's not just any product. They have to be shown to be unreasonably dangerous. So, you know, American companies will spend quite a bit of money making sure that their products are not unreasonably dangerous. That some products cannot be made perfectly safe, but it's not thought to be unreasonably dangerous for a car to be involved in automobile accidents. Yes, the car manufacturer knows that the car will be on the road and there's a chance that it will be involved in an accident. He's not being liable for producing a car that was driven on the road. He's being held liable. He can only be held liable by somebody showing that the car was in some way defective that made it unreasonably dangerous. In other words, more dangerous than it is already. It's already dangerous. It's already got gasoline in its tank, and it's whizzing past other cars that are going at high rates of speed. It's already a dangerous instrumentality, very dangerous. So a lot of deaths have resulted from that. So it has to be an unreasonably dangerous product. Law likes to use words like unreasonable and reasonable. So let's talk about how strict liability came about, because at common law it was unknown. And it didn't come about until 1868. In 1860, Rylands paid contractors to build a dam on his land, intending that it should supply his mill with water. Well, it actually wasn't his mill, it was somebody else's mill, but he's responsible for he owns the dam. And the dam leaked into Fletcher's property, damaging his property. Fletcher sued, but was unable to prove that the dam was negligently constructed. The court nonetheless held the contractors absolutely liable, that is, strictly liable. On what basis did they do that? Well, I have a long opinion. And in the opinion they say, well, the Rylands had built his dam, and in the process he had put the water up this mountain side where God didn't place it. God would have allowed the water to flow down. So by doing that, he created an abnormally dangerous situation, an unnatural case. Unnatural because that was not the way God had planned that piece of earth, right? Something like that. It's much longer. I mean, it goes on for pages and pages, so I can't possibly give you the entire opinion here. But that's the gist of it. Is that it said that this was an unnatural thing. And that's where we get ultra-hazardous liability. So you have to show that there was something unusually dangerous about this. And so they're arguing that it's unusually dangerous to construct this dam. And so they're holding this contractor who owns this dam responsible for the damage. So obviously if you do have a dam to this day, you ought to be inspecting the dam, make sure there isn't a leak. You find that this happens sometimes. In West Virginia, there was a operation, a coal mining operation, that was owned by not a coal company, but a company that used coal in its production of its product. And they had built these dams to contain water, and what they built are called slag dams. these slag dams are basically made out of stuff that you dug out of the coal mine. You pile it up, so you have a pile of rocks and mud and timbers and slag, which is coal you can't use. Okay, you stack that up and you've got a dam. Okay, but this is not a very stable dam, and so you need to have that inspected. And you know, it was inspected, and the engineers who inspected it told the plant manager that, you know, there's a real danger. We've had unusual flooding this spring, and the dam is close to bursting. If it rains more, it's going to burst, and if it bursts, it's going to go through the town on that narrow mountain valley, and it's going to wipe out those houses, it's going to wipe out everything there. People will be killed. The plant manager, however, went and prayed, and he decided that God wouldn't let that happen, and he didn't do anything. He didn't shut down the operation, because they were adding, see what it was is they were adding water from the operation. That would be in addition to rainwaters. And so the dam burst, and it was a terrible disaster, made news, and the company got sued and wound up becoming liable. Many of the people who worked, lawyers who worked on it, worked for free. Some large firms sent people to work for free on this national scandal, disaster, and you know, there was a book written about that, which really is a horrifying tale. It's one of the scariest stories I ever heard about a poor man who was trying to save his family, and he lost all of his family members, his wife and I think 6 kids, including an infant, who he hung on to till the very last when he was overcome in the water, being buffeted about, thrown into rocks. He managed to live, but he at some point realized his daughter, who he was still holding, was cold and dead, and so he wound up letting her go. He didn't want to do it, but that's what happened. So it's kind of scary. The dam leaked into Fletcher's property. Okay, that was it. So nonetheless, so sued, but he was unable to prove that the dam was negligently constructed. So they didn't have strict liability. They didn't have ultra-hazardous liability at that time. And the court decided nonetheless to hold the contractors absolutely liable. Is that different than strict liability? Sounds different to me than strict liability. At least you have to prove something with strict liability, but they're absolutely liable. So we won't get into the distinction between absolutely liable and strict liability. All you need to know is they were holding Rylands liable even though he was not at fault. There's no evidence that he had built a shoddy dam or that anything was wrong with the dam. I don't know whether he produced evidence that he had it inspected, but nobody could prove that it was in any way faulty. It was faulty though, wasn't it? And so that's why the judges kind of ruled the way they did. So that case is picked up by United States courts, by Australian courts, by Canadian courts. That was very common. All these courts of former British colonies would oftentimes look to precedents generated by the English lords, the high lords of England, would issue these decisions, and they would look at them as precedent. And you know, they would read them, and if it seemed reasonable to them, they might actually adopt them, and that's what happened. In all states in the United States, we have ultra-hazardous liability. Ryland v. Fletcher. We think that the true rule of law is that, this is from the court, is that the person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief, so basically the water is likely to do mischief if it escapes, must keep it in at his peril. So, you know, if you have a tiger, you need to keep it in a cage, and if it escapes, you're going to be liable. Strictly liable. Doesn't matter that you say, well, you know, I was transporting the tiger on a train and there was a train wreck and he escaped when that happened because the cage was broken and that's how he escaped. I'm not at fault for that. Well, no, you're not, but you are being held strictly liable because you've kept a tiger. And we don't care that you're a circus or a zoo or what you are. You've got to pay those individuals who may have been injured by that tiger, if any. So you're going to be doing everything you can to get that tiger before he does any mischief, right? You must keep it in at his peril. And if he does not do so, is prima facie. What's that mean? Prima facie means in the first place. answerable for all the damages, meaning he's going to have to pay for all the damages. That's what answerable means. He has to answer for it. He's primarily answerable for all the damage which is the natural consequence of its escape. In this case, the water escaped from the dam, flooded the other person's property, and harmed his property thereby. Anything likely to do mischief, so to the degree it was harmed, he's got a claim against the Ryland. To the degree anything likely to do mischief if it escapes becomes anything abnormally dangerous. In later cases, they talk about it being abnormally dangerous. This court did not talk about it being abnormally dangerous. He said it was unnatural. All they said, and it said that God didn't place it there. They said it was, against the laws of nature or something. So they didn't say abnormally dangerous, but in later cases they said, well, the abnormally dangerous keeping of something would qualify. So usually you had to have something other than water to do that, but sometimes the cases did involve water also, and now it becomes anything ultra hazardous. So that's a little bit, maybe a little bit more dangerous than abnormally dangerous, right? Ultra hazardous sounds that way. So the courts rule on that. So what do we mean by that today? First off, let's take a look at this. There has been some criticism of this case, and so basically some people say, well, that Ryland v. Fletcher case, the case on which strict liability was first enunciated, proclaimed, should have been decided under nuisance law. And indeed, I think it could have been decided under nuisance law. It sounds like nuisance. There are two kinds of nuisance proceedings. One is a private nuisance, which would be brought by a single individual, and the other is a public nuisance, which has to be brought by some sort of government official, like the mayor or the chief county administrator or maybe the governor. Somebody who has the power to bring a suit on behalf of the people would have to bring this suit on a public nuisance. They tend not to, because they're usually wanting to run for office and claiming that they create jobs. And if they bring nuisance suits against a employer, they may be criticized for destroying jobs. Okay, so they usually don't. So oftentimes private, even in cases where you would think it would be the public official, because a lot of people are harmed, private individuals need to get together sometimes and form an organization in order to hire a lawyer to bring a major suit where there's damage to a lot of people, and no one individual wants to pay for a suit on which he's only going to get a small part of the claim, because other people could then later join the suit. So you need to actually organize that. So we're going to leave that there. We'll return to nuisance law when we get to environmental liability. So it comes in that case too. So you think about it, water escaping from a dam sounds like an environmental danger, right? If you have the water rising and destroying property in California, as may happen soon, or other cities along the coast that might find themselves inundated and having expenses, can they sue? Who are they going to sue? Is it an act of God? Wouldn't it be better to avoid that from happening with some sort of environmental effort? We haven't seen enough of that yet, so we'll see in the future how this works out. And so all of us will probably likely, through government, wind up paying for our neglect of the environment. Engaging, ultra-hazardous activity. You're going to get it if you're engaging in manufacture, use, transport, or storage of certain products. Usually creates liability to anyone foreseeably harmed by that activity. So this proximate cause is still an element. That every time you ever see foreseeable, that's going to require proximate cause. And so it has to be something that is predictable if something goes wrong with your explosive substances. So let's say you are a contractor and you blow up stumps and you use dynamite. You have a guy who has all your blasting caps and your dynamite in a box, and he keeps track of every one of them. He has a record on what happens with each one of them. At the end of the day, if it turns out that there are that he's missing some, then he goes on a search, and if he doesn't find it, he'll alert others, and they'll go on a search, and they'll try to find where that is, because otherwise some trespassing kid may come on the site and blow himself up or otherwise injure himself, and you'll be liable. And even though you're not at fault, even though you might say, well, isn't he contributory negligence? Maybe, but you're still going to be liable to some extent, even in a state that has modified comparative negligence. And of course, if you're in a state that retains common law negligence, maybe not. But kids who are not likely to be found to be contributory negligence by juries. Anyway, explosive substances, dynamite, gasoline, poisonous chemicals, substances that will burst into flames. You can include that with explosive substances. Poisonous chemicals, such as they had at Bhopal, and actually in West Virginia in a city called Institute. In both of those cities, the same, well, it's a gas that we'll talk about later. Maybe not tonight, but it was a gas, MIC, that escaped and caused 16,000 deaths in India, and 40,000 people were severely disabled and otherwise harmed by this gas substance, which came into this very crowded area. They had built, Union Carbide, which is an American company, had built this plant. That's why we're talking about in terms of American law. And they would become liable, strictly liable, hazardous, because India was a British colony too, and they have the Ryland v. Fletcher holding rule. And therefore, and American lawyers were standing in line to get those litigants there. The same thing happened in the next year, so that happened in 1984. In 1985, the same thing happened in West Virginia, in a city called Institute, but it wasn't near the city, so the casualties were a lot less. The officials at Union Carbide tried to claim that they had taken steps to make sure it didn't happen, but obviously whatever steps they took were not adequate. In both of the cases, the officials were never notified when the leak began. So in the case of West Virginia, it was only 20 minutes. I think it was a little longer in India. And so things had been improved, but the same thing happened because it was a leaky valve in India, and it was a leaky valve, the same leaky valve, the same design in that. And so basically they need to be testing their valves if they're going to be, shooting this toxic gas through them. And the gas that was being shot in Institute was derived from MIC and wasn't as potent as MIC itself. And so I'm going to include in the video a link so you can see a report on it from ABC News, Dan Koppel, or Ted Koppel, right? So I'm already forgetting his name. He was a famous reporter at one time. Has an interview with the people, and he has a person there from Union Carbide and an environmentalist, and they kind of square off. And the thing I noticed about it was that I saw the Union Carbide official walking over and bullying and basically talking over the environmentalist, who was oftentimes interrupted. He wound up interrupting her, and so it's sort of like I've seen this so often with oftentimes business people who will do this very aggressively, defending their company for profits or whatever. They see a moral responsibility only to the shareholders, not to everybody else, and therefore will not act with decorum. And Ted Koppel, didn't do much to stop her. As a matter of fact, he kept saying to her, well, I want you to be able to give your side of the story. And she was giving her side of the story whether you wanted her to or not, and she was not letting the other side give his side of the story. I couldn't hear a lot of what he was saying. So you'll be able to look at that and see this kind of behavior is endemic. It's a sign of something that's wrong with our society. So the last substance is radioactive substances. You only need a little bit of a radioactive substance. A little bit of that can cause you cancer years later. 20 years later, you might wind up from having been invaded by invisible radioactive isotopes. Having those things in your body can cause cancer years later. John Wayne made a film out in the Nevada desert, and everybody on that film, this was after they exploded the atomic bomb, everybody on that film wound up getting cancer, including John Wayne, who had been a very healthy individual. And I don't think he actually smoked cigarettes, or very rarely smoked cigarettes, didn't smoke much. He wound up getting cancer. And all the soldiers who had witnessed this thing, I think, also wound up getting cancers, who had witnessed the atomic bomb, and the actors and the directors and the cameramen. all of them wound up dying of cancer if they didn't die earlier or something else. So thank you very much. We'll see you